is a movement like we've never seen in the history of our country.
Wisconsin is Trump country.
And that's what this fight is all about. We're taking on the failed political establishment and restoring government of, by, and for the people. It's the people. You're the people. You won the election.
We love this country. We love Donald Trump.
Promises made, promises kept.
We support President Trump.
This is epic.
Donald Trump is our president!
With every last ounce of heart and hope and sweat and soul, we are going to make our stand. We are going to stand for liberty. We are going to stand for justice. We are going to stand for freedom. And we are going to stand for the sacred rights given to us by the hand of Almighty God. You joined our movement, the greatest movement in the history of our country. You protected your family. You defended your dignity. You recaptured your destiny. And you took back your country with that great election 2.5 years ago. We are one united movement, one united people, and one United States of America.
Ladies and gentlemen, please welcome the President of the United States, Donald J. Trump.
You have always been loyal to this nation. Now you finally have a president who is loyal to you. Every day between now and November 2020, we are going to keep on working, we are going to keep on fighting, and we are going to keep on winning, winning, winning. We will make America wealthy again. We will make America strong again. We will make America safe again. And we will make America great again. Thank you.
Good morning, good evening, good afternoon. Welcome, welcome, welcome. As promised, we're going to go through the second half of the document of the Mar-a-Lago raid that the Trump legal team released yesterday. Also, there's a couple small things that I wanted to get to before we get started with today's show. One of which is that it looks like Joe Biden will be excluded from the ballot in the terrible state of Ohio. They did something right. Even a blind squirrel finds a nut every once in a while. But the legislature in Ohio and some of the individuals there have said since he will be nominated after, he will not be placed on their ballot in Ohio. So, of course, there'll be legal challenges, all that kind of stuff. And we will see how that turns out. But as of now, Joe Biden will not be on the ballot in the battleground state of Ohio. Again, though, I'm sure there'll be a ton of legal challenge to it, and we'll see how it all ends up there. But that's the word right now, and that would be good news for President Trump because that's quite a few electoral votes in a battleground state. So I'm all for it. Also, something that I've been watching, and I know many of you have been watching as well, the Boeing Starliner mission, the first crewed astronaut mission for the Boeing Starliner, will be indefinitely delayed. They continue to have issues with the craft. If you've been keeping up with my community posts, I've been posting updates to the situation, and it appears now that they are going to indefinitely suspend the service of the Starliner. We might see it eventually, but this crop of astronauts will not be flying at all. because, like I said, their time's up. They have to be quarantined and different things of that nature. So they're going to miss out on another flight to space because of Boeing's whatever you want to call it. So unfortunate for them, but they might have literally dodged a bullet there since everybody knows what I think of Boeing. But with that being said, we'll go ahead and get right into the document and continue down that path. Like I said, we started last night. This is about the raid on Mar-a-Lago. Several things that were unconstitutional, downright illegal, didn't make much sense. The highlight of the last show was the fact that the Biden administration had basically a shoot on sight order with very little direction. So any of the agents that responded to Mar-a-Lago could have theoretically shot the president of the United States. And there's all kinds of implications for what that meant and what that could mean. So there's that. Also, went through some of the Fourth Amendment challenges to everything, and things of that nature. So, yeah, let's get into it. We are on page 11 of the document, as you can see here, and we're getting a little bit further into the whole thing. So it says the Mar-a-Lago raid was executed in egregious fashion and in bad faith. I think we can all agree on that. That's kind of been my thought from the beginning. There's a lot going on here, and a lot of it could have been easily rectified had they just called President Trump or called his attorney. There was every indication and part of the Trump team's indication that they were ready to negotiate or ready to talk, and the raid was really not something that should have been done. And again, that was shared by the FBI from what we saw from the beginning. That sentiment was shared by the FBI. So and it went forward on the advice of basically one individual. So that's not ever a good thing to have your entire democracy and your presidency hinge on one individual's personal bias. So yeah, it's again one of those. It's a terrible situation, and they put this agent in a terrible spot, but they don't care, and it's justify the means. So, the special counsel's office cannot save this search by reliance on good faith exception under United States versus Leon. The officers do not act in objective good faith, however, if the warrant is so overly broad on its face that executing officers could not reasonably have presumed it to be valid. President Trump is seeking evidence bearing on this issue, and pending motions to compel and fact-finding will likely be necessary before the court can resolve it. Hey, what's up, Stingy? Oh, look, you get some more of my pennies. Thanks, buddy. Stingy's been a member for 11 months. Damn. I've been monetized almost a year. That's crazy. But thanks, buddy. I appreciate it. So, fact-finding will likely be necessary before the court can resolve. Reasoning that both parties should be given an opportunity to present evidence touching upon the conduct of the officers and remanding for a hearing on good faith issue. However, several known circumstances already counsel against the finding in favor of the office on this fact specified inquiry. With no basis whatsoever in the affidavit or otherwise, FBI agents searched the private bedrooms of the First Lady and President Trump's youngest son, Walter versus the United States. A warrant to search for a stolen refrigerator would not authorize opening of desk drawers. And that's what we talked about last night, is it has to generally, a warrant has to be so very specific. You can't just say I want to search for any box or any box that touches any box, for whatever the case is. Like, there generally has to be a very specific set of facts, and a very specific instance where you're searching for one thing, and you get to search in a specific area, and that's not at all what happened here. The entirety was they got to search whatever they wanted. They got to search in rooms that definitely weren't used for presidential business or presidential anything. They just got free reign of the place. And that's one of those where we cannot allow that to stand, because that's dangerous to the public. And you'll start to see that in other situations where defendants don't have the presumptions or the protections. They just no, we want to search, all of this stuff, and that's just insanity to think that that's something that's okay. They shouldn't be able to overly broad search anything. That's not how our system's set up, and they should be held accountable for it, because it should be something very specific. They should be allowed to search one specific area, and that should be it. And that's not at all where this went. This went wherever they wanted to look, they were okay to look. Whatever they wanted to uncover, they were okay to uncover. And it really does set a dangerous precedent for everything, because now you can essentially just do whatever you want. And that's a terrifying thought, that the government has that power. It's unfortunate, because the government shouldn't have that power. It shouldn't be allowed to carry on like that. It makes it really dangerous moving forward, with everything. So I hope that, if no other grounds, that it gets rectified there, because this becomes an issue. It becomes a serious issue if this is the way that business is going to be conducted and handled. So there's hopes that obviously they're looking for some kind of injunction from the judge, or some kind of intervention, that at least they get granted on that specific area. But it remains to be seen. So blah blah blah. The FBI's photo log demonstrates that the agents took extensive photographs of those rooms 42 and 27 respectively, for no apparent reason. Well, we know what the apparent reason was. The apparent reason was to leak them to the press so that they could have some win somewhere. This was always a political stunt. It was a stunt to be able to do whatever they wanted and put it on the front page of the major newspapers. I mean, that's realistically what this whole thing was. It may have backfired a little bit on them, but they're still getting away with it without really any kind of they're not paying for it in any way yet. So there was no factual basis for the agents to rummage through rooms not specified in the warrant, and not surprisingly, they seized nothing from these other rooms. So again, they didn't take anything. They shouldn't have been there, and it truly is just an utter violation of President Trump's rights. And I think we should be held to a higher standard than that, and our law enforcement and our government body should be held certainly to a higher standard than that. So, but clearly it was not here. So, I mean, it is what it is. So, nor was there any basis for the FBI to bring firearms into Mar-a-Lago. So this is the interesting part. This is where we ended ended the last stream with the whole firearms and all that good stuff. Because this was my concern from the beginning, is that they seem to have been wanting to trigger some kind of major issue. I think it was, like we talked about last night, either some kind of shooting the president or getting the president to react so that they could take some kind of action against him, say that his, guards or service or whatever, open fire on an FBI agent, poor little FBI agent, and that would have been trouble. That would have been something that could have gotten way out of hand. So luckily it didn't. Yeah, they wanted the headline "Trump shoots at the FBI" or Trump's whatever shot at the FBI. They wanted something to put somewhere that they could say, "Oh, see, he was trying to kill FBI agents," and I don't think that's at all what his intention was. But yeah. So there was no threats to and no risk to agent safety arising from the allegations relating to the possession of documents at a premises already guarded by Secret Service. But the evidence appeared to have done so based on documents produced in discovery in order to search for alleged contraband that they pretended was life-threatening in Mar-a-Lago's gym and kitchen, 5 of 4 pictures respectively. So that's another point. There has to be some kind of proportionality, and it has to be. You can't just say, "Oh, he's dangerous because X, Y, and Z." Like, there has to be proportionality, and like they were talking about, the crime has to fit the ask. And when you're talking about some documents, that doesn't fit going in guns blazing in the gear. And to be honest, rarely do they ever fit. They normally are incredibly heavy-handed in these type of things, often very unnecessarily. So it's no surprise that it happened this way. It's just unfortunate that it happened this way, because there was serious risk to everyone because of the actions taken by the FBI. Because of this one individual. And I can't stress that enough. Again, this was one individual. This wasn't the entire brass at the FBI. Of course it was, greenlit, but they relied on one individual, and then of course Merrick Garland, to make this call. And I think it was the wrong one. So the government had already acknowledged that, notwithstanding the constitutionally infirm capaciousness of the warrant, the FBI exceeded its scope. See Trump versus the United States 625. The government also acknowledged that it seized some personal effects without evidentiary value. The agents improperly seized passports, medical documents, correspondence related taxes, and accounting information. Well, the tax information was probably, since they've been infatuated with his tax situation, they probably wanted to be able to open an investigation to prosecute more crimes on that front as well. So I understand the tax part of it, but it's a bad look. It really is. It's a really bad look for Department of Justice to go forward with something like that, or Department of Injustice. So I don't get what the end game was, other than try and get some kind of response or some kind of action out of Trump or the Trump administration. This was just a dumb move all the way around, and it's so frustrating that they took such an action that put people's lives at risk for a political stunt, and that's all it comes down to. And it's really frustrating. I'm still curious why they said to wear no identifying clothing and hide law enforcement indicators. So they opined on that a little bit in the previous one. Obviously Trump's legal team, but yeah, I mean I think it just goes to the narrative of they were trying to entice Trump or his security team or bodyguards, or who knows, maybe it's a dry run for fuck it, executing the president. Maybe that's what it ends up being. I don't know, but it seems like another one of those things where something could very easily get blown out of proportion, and somebody could get hurt because they wanted to have a political stunt. And that more and more is what it seems like it's turning out to be. So lastly, evidence of a politically motivated animus towards President Trump by prosecutors, agents, NARA personnel, and White House officials is relevant to the court's analysis of the suppression remedy. I would agree with that. See United States versus Herring. Reasoning that a precondition to the applicant of the exclusionary rule under Leon is misconduct by police and adjudicants to the law enforcement team, emphasis added. Some of the evidence had already surfaced, but much more must be disclosed by special counsel's office for the reasons set forth in the defendant's motion to compel. So they're saying basically that they don't have all the information, and we know how likely the government is to go ahead and give that up. So it's a good thought, but realistically, you're probably not going to ever get that information, Mr. President. They're going to keep that closely guarded like they do everything else. It should be public record, and you should be able to get some kind of something from somewhere, but we all know that's not going to happen. So you'll probably never get the answers, and we'll probably never get the answers. So that moves us into the special counsel's office violated President Trump's attorney-client privilege. This is kind of one of those sacred rights. You want to be able to talk to your attorney, and you should be able to talk to your attorney about these kind of matters. And very clearly, they've trampled all over his attorney-client privilege more than once, several times, in fact. And it seems like there's not going to be any remedy for that one either, because they continue to do it on the stand in New York with him talking to the prosecutors talking to Cohen. Well, obviously Cohen was his attorney. Probably a bad call on the Trump administration's part, but he was his attorney, and he should be entitled to attorney-client privilege. And it's apparent that he's not going to get that in that case or any other case. So, again, trampling on another right that should be afforded to the former president or anyone for that matter. So, just another right that is completely trampled and completely stepped all over, and there's no regard for it, because these people don't care. They don't care what. It's just, oh, we got Trump. That's all that matters to them. So, but apparently dissatisfied with the outcome of the Mar-a-Lago raid or concerned about the manner in which it was conducted, the special counsel's office took extraordinary and unlawful steps to gain access to privileged communications between President Trump and his attorneys. The unconstitutional nature of these efforts illustrated by the fact that the office relied on a constitutionally defective Mar-a-Lago warrant to bolster its motion in the District of Columbia. It was an error to apply the crime fraud exception, and the resulting evidence must be suppressed. So, I mean, that's pretty simple. I forgot what it's called. Somebody said it last night when we were talking about it. Fruit of the poison tree. It's obviously fruit of the poison tree information, and there shouldn't be anything to where he has to use that information to prosecute. It should be specifically that's thrown out, but they're not going to do that because they have no morals or ethics or ability to do things correctly. So, unfortunately, again, we're stuck with them acting in bad faith and doing things that are not conducive to the way they should be done. So we're stuck again. So here they lay out relevant facts. So now we get a little bit of an indication of their fact pattern, where they're going, what they're thinking, that kind of thing in this document that I prepared. So relevant facts. The May 10, 2022 subpoena to President Trump's office. In April 2022, President Trump engaged attorney person 18. And I actually don't know who that is right off the bat. And obviously they redacted it for a reason. So maybe it's not one of his well-known attorneys that he has working for him generally. But I would like to I'd like to know who this specific attorney is. But we'll probably never get that information. So yeah, but so person 18, I don't know who it would be. He has dozens of attorneys, so who knows? At the time, attorney blank, also redacted, was also representing President Trump, initiated contact with Brat, who is the FBI agent, in late April. At the time, NARA and DOJ were pressuring President Trump to present executive privilege claims relating it to the 15 boxes, which he should have been able to, but they wouldn't have cared anyways. On May 11, 2022, Brat sent person 18 a subpoena addressed to the custodian of records for the office of Donald J. Trump. The Trump office subpoena was dated May 11th and returnable on May 24th, which Brat later extended until June 7th. And it called for all documents or writings bearing classification markings. See a bunch of different stuff. Referring to person 18 as Trump Attorney 1 and blank as Trump Attorney 2. Number 2, the May 23rd, 2022 meeting at Mar-a-Lago. On May 23rd, 2022, person 18 and blank met with President Trump at Mar-a-Lago, CECF 8555. Subsequently created an audio recording with his impressions for the meeting, which was transcribed in connection with litigation in the District of Columbia. The June 3rd and 2nd, 2022 meetings at Mar-a-Lago. On June 2nd, person 18 again went with President Trump at Mar-a-Lago. After speaking to President Trump, person 18 reviewed the contents of the boxes in the basement storage room. Person 18 identified documents that he believed were responsive to the Trump office subpoena and asked Brat and the FBI to collect the materials at the Mar-a-Lago the following day. On June 3rd, person 18 met with Brat and FBI agents who had traveled to Mar-a-Lago. An attorney named person 12 also participated in the meeting, and blank provided a written certification of compliance with the Trump office subpoena. So there was already a compliance. Wow. So there was already something there saying that they were going to comply in writing and they still went with it. Referring to person 12 as Trump attorney 3, person 18 gave Bratt, the FBI, a sealed red weld containing approximately 38 documents that person 18 believed were responsive to the Trump office subpoena. During the meeting, President Trump spoke to Bratt and the FBI agents voluntarily, and he permitted them to view the storage room, which was probably looking back, was probably a significant error. Because I think once they saw the storage room, they thought that they had an opportunity to dig further and get more into things. So I think that gave them justification and probably somewhat the ability to kind of get a sneak peek inside the facility, inside the office, and know where they kind of wanted to head as part of that subpoena. So that was probably an oversight by the president, but trying to cooperate, and that's why you never try to cooperate, because fuck these guys. But anyways, so yeah. As with person 18, May 2022 trip to Mar-a-Lago, person 18 created an audio recording from, I already read that one, sorry. For Trump Organization subpoena on June 22nd, 2022, Bratt issued a subpoena to the Trump Organization for Mar-a-Lago CCTV footage. Bratt emailed that subpoena to really long redacted, and blank forwarded to person 18. On June 24th, blank discussed the Trump Organization subpoena with President Trump during a phone call. That was a mess too. So the whole camera thing was significantly inappropriate on the part of the Department of Justice and the FBI and parties that be. There's no reason why President Trump had to turn over footage of Mar-a-Lago to the FBI. It was kind of his footage. I probably would have hung on to it too. So again, it seems to be a significant overreach by this administration's FBI. And I mean, again, I think he was trying, for the most part, to be able to just work with them and give them a little bit so that they would maybe not come in and do ridiculous things, but it ended up not being the case either. So on November 21st, 2022, God, there's so much redacted. It's almost difficult to read. Special counsel Julia Edelstein issued a subpoena calling for testimony and documents from person 18. The person 18 subpoena, the subpoena called for materials relating to, among other things, instructions or guidance concerning the Trump office subpoena. Person 18's June 2nd, 2022 search of the storage room and the certification executed by person 12 at 12 USA, lots of numbers, beginning on the December 8th, 2022 through counsel person 18, produced non-privileged documents in response to the person 18 subpoena. Person 18 provided a privilege log to the special counsel's office on or about January 6th. On January 12th, 2023, person 18 declined to answer certain of the office's questions during testimony before the grand jury. And probably a plead the fifth kind of thing, but I don't know. I didn't see it. But on January 25th, 2023, David Harbach issued a subpoena calling for the testimony and documents from blank. The blank subpoena, through counsel, blank informed the special counsel's office that she would invoke attorney-client privilege if required to testify. And there's another one where his rights were just completely trounced. Like he didn't have any rights to anything. They just basically did whatever the hell they wanted, and he just kind of had to deal with it. And that's unfortunate because we have rules and laws and ways of doing things for a reason. It's not just because you feel like it. So there's another instance where he just wasn't afforded what he should have been. So again, very frustrating. But so motion to compel. So we get to the motion to compel. What they are hoping to get out of this situation, which doesn't seem to be much, honestly. But anyways, their motion to compel. On February 7th, 2023, the Special Counsel's Office filed an ex parte motion in the District of Columbia to compel Person 18 and blank to answer questions and produce documents regarding to 6 topics. 6 individual topics. 1, efforts to determine where documents responsive to the May 11th subpoena may be located. 2, why Person 18 believed all responsive documents were in the storage room at Mar-a-Lago. 3, circumstances surrounding the selection of Person 12 as custodian of records. 4, the sources and basis for the false statements in the certification and reason for edits to the certification. 5, the awareness of former president or anyone in his office regarding the certification or approval of the certification. And 6, the phone call between Person 18 and the former president on June 24th, 2022. In reply to the opposition submissions by President Trump and Person 18, the office conceded that Person 18 independent assertion of the work product privileges raises unsettled questions about the application of the crime fraud exception to the opinion work product. Acknowledging concerns about the office's aggressive position in the opening submission, they agreed to seek only Person 18's fact work product. Following a March 9, 2023 hearing attended by Special Counsel's Office and counsel for President Trump and Person 18, Judge Howell granted in part and denied in part the motion. The court ordered Person 18 to produce documents reflecting his efforts to comply with the Trump office subpoena and that may have informed his knowledge of President Trump's organization subpoena. Judge Howell also required Person 18 to produce May 2022 record and the June 2022 recording based on the reasoning set forth in these separate orders. So even that he went through the process, they still try to compel him to produce these records that probably shouldn't have been produced. There doesn't seem to be any legal basis for a reason that he should have had to produce these orders or anything like that. Again, it just seems like it's a significant overreach by pretty much everyone involved. I don't know why there was ever any thought that he was required to produce this kind of thing. Just seems kind of ridiculous to me, being honest, but they had to have had some kind of there had to be some kind of justification coming from somewhere internally from this judge, because it seems like they're not attacking this judge very heavily. So there had to be some kind of basis in law for that ruling, or maybe not. Maybe they're just not going after the judge for whatever reason. But a lot of questions there, a lot of interesting things. So, Judge Howell also required Person 18 to produce the May 2022 recording and the June. Oh, I thought I got. Yeah. based on reasoning set forth in separate orders. On March 22, 2023, the D.C. Circuit Court denied motions by President Trump and Person 18 to stay Judge Howell's rulings. So the D.C. Circuit, which is generally pretty liberal, also weighed in. 7. Compelled testimony. On March 24th, 2023, the Special Counsel's Office required Person 18 and blank to testify before a grand jury in the District of Columbia, despite the lack of venue for any of the offenses under consideration. The prosecutors questioned Person 18 extensively regarding inter alia, the otherwise privileged communication with President Trump, the May 2022 recording, and the June 2022 recording. So even though they didn't happen in DC, they still made them go to DC, which can be a significant, I mean, for anybody else, it would be something that would be quite ridiculous to compel. And again, it's the thought that, oh, Trump's not above the law. Well, he's also not below it, and he's also afforded the same thing that everybody else should be. And it's frustrating to see that they don't care about his rights. They just, make him come to DC for a hearing when none of these crimes took place in DC or anywhere near DC. So that's unfortunate to see his rights again just get completely trampled for no apparent reason. Of course, Trump can go to DC to testify. Maybe his lawyers wouldn't be able to, nor should they have to. So again, it's just it's where they don't care about the law or how it affects people. They just do what they want and expect them to comply, and that's not the way it should be done. So anyways, applicable law, attorney-client privilege, and work product. Traditionally, the attorney-client privilege, like the privilege extending to attorney work product, is sacrosanct. The attorney-client privilege attaches, of course, to confidential communications between an attorney and client for purposes of securing legal advice or assistance. And that's really important because you want to be able to gain that legal advice when you need it, and you should be entitled to get it when you need it. So again, a pretty dangerous precedent to set by not allowing that product to become available. You should be able to get representation or the advice or whatever the case is that you're entitled to, and it's obvious that President Trump was not afforded that in this specific instance. Protection of this privilege promotes broader public interest in the observance of law and the administration of justice, and encourages full and frank communication between attorneys and their clients. The work product doctrine recognizes it's essential that a lawyer work with a certain degree of privacy, free from unnecessary intrusion by opposing parties and their counsel, because you should be able to talk again with your attorney and not fear that information is going to get back, because that's not how our system was set up. So you should be able to have that conversation without it being broadcast to the world. And again, that should go for President Trump or anyone else. So the work product doctrine recognizes material that reflects an attorney's mental impressions, conclusions, opinions, or legal theories is referred to it as opinion work product. Opinion work product enjoys nearly absolute immunity and can be discovered only in very rare and extraordinary circumstances. An attorney's independent assertion of the work product privilege, on the other hand, stands on a very different footing because the attorney's privilege is based on the attorney's interest in protecting his opinions and thoughts processes from disclosure. This is a protection that benefits all of the attorney clients because it accords the attorney a measure of privacy within which he can candidly compose his thoughts. The crime fraud exception. The crime fraud exception only applies in rare circumstances. Dremico. First, there must be a prima facie showing that the client was engaged in criminal or fraudulent conduct when he sought the advice of counsel, and that he was planning such conduct when he sought advice of counsel, or that he committed crime or fraud subsequently to receiving the benefit that counsel's advice. Secondly, there must be a showing that the attorney's assistance was obtained in furtherance of the criminal or the fraudulent activity, or was closely related to it. And there was no indication or showing here that Trump was only getting advice of attorneys so that he could further a crime or a set of crimes, which is what it says that it needs to be. So if Trump wants to commit crimes, I'm sure he can do it all by himself. He does not need anyone's help. So so he should be able to should be able to do that. An attorney may assert work product privilege with regard to opinion work product even if the client has used the attorney's services to commit a crime or perpetrate a fraud, so long as the attorney was unaware that the client was doing so. Once the grand jury has heard testimony that a putative defendant contends was protected by privilege, appropriate remedy is the post-indictment motion in limine to suppress the use of evidence as testimony in a trial. So basically, in English, there's a way that you have to do things. You can't just assert that it's there. There has to be a reasonable finding of it, and there's a process for that. Like there's a process for most things. So again, it's not just something where the government can say, "Yeah, we think it's here, so it's here." There has to be some indication that it's actually there. So, discussion. 1, the special counsel failed to make a prima facie showing. That's what we were talking about. Like, I'm pretty sure that that's not going to be a difficult one to prove. Judge Howell erred in the finding that the special counsel's office had made a prima facie showing with respect to 18 U.S.C. 793C, 1001, 1512, and 1519. Reference 793E to access privileged communications with especially problematic in light of the impermissible risk of arbitrary enforcement arising from the statute's unconstitutional ambiguity. I think there's a lot of ambiguity here. Like there's a lot of they didn't, from any of the documents that I've seen, they haven't really showed much of anything. They just kind of asserted that this was happening and didn't have a showing of anything at all. And again, that's not the way that things are supposed to operate. There's supposed to be a showing and you're supposed to know what's going on, and that didn't seem to take place here. It just seemed like it was kind of thrown out there. Like there should have been much more of a process that was undergone, and not just we think Orange Man bad, which is basically what their argument's been since the beginning, is Orange Man bad, so screw him. And that's a banana republic, and we shouldn't have that here. We should not. But anyways, reliance For all of the statutes, the office's proffer was limited mostly to what Judge Howell described, they spelled judge wrong, described as choreography of box movements prior to person 18 June 2nd, 2022 search of the storage room. Finding curious, the absence of any video footage showed the return of the remaining boxes to the storeroom. So when they got caught, they tried to cover their tracks. Surprise! Surprise that the FBI is corrupt and would do something kind of stupid like that. I know everybody's shocked, so I'm not. The office lacked and still lacks evidence demonstrating that President Trump knew there were marked classified documents in boxes that were allegedly not returned to the storage room. Seeking to bridge that gap, Judge Howell cited an assertion attributed to President Trump in May 2022, recording that Hillary Clinton, redacted, even if made, the remark was not inculpatory if DOJ's decision not to prosecute Clinton is considered valid. I again don't like that I understand what they're trying to do with the Clinton did it, so we should be afforded the same. But I don't think that you even have to. I don't even think that you have to. You have to do that. Like there's other ways that you can do it without having to bring up Hillary's name. I would have preferred that they went a different way with that, instead of using the example. That being said, she's the only other applicable instance, because of her her abilities and all that kind of stuff. She's the only other comparable instance where you could have something like that. So I get why they're doing it. I wish they would have went a different way about it than saying Hillary did it, so we should be able to. But I get the premise of why they're doing it. So it's just I would have went somewhere else. But even if made, the remark was not. Oh, I already said that one. In fact, although at least one prosecutor who participated in the investigation of Hillary Clinton thought there were pretty good arguments that there was a waiver of privilege, the prosecutors did not pursue it. Hart's OIG report 17 and 102. The prosecutors reportedly made that decision because Clinton's attorneys lacked nefarious intent or criminal mens rea, which seems to be an easy way to get out of things recently. Yeah, they didn't have intent to do it. Well, seems like they did. Seems like she knew what she was doing. She was there long enough, and probably should have known what she was doing. So, and if she didn't, there's more of an issue there than anything. Special counsel's office conceded that the same was true for person 18 and blank, but the Biden administration's political objectives required the office to take a different course in this case. Nevertheless, Horowitz's OIG report illustrates the flawed nature of the court's reasoning regarding this alleged comment by President Trump. Judge Hall acknowledged that, one, President Trump could plausibly claim they did not know what person 18 and person 12 wrote in their June 3rd, 2022 certification. And two, there was no evidence that President Trump deliberately retained or even was aware of the particular 4 classified marked documents located in his counsel at Mar-a-Lago in December of 2022. The court, however, placed undue emphasis on a question attributed to President Trump. We just don't respond at all or don't play ball with them. Wouldn't it be better if we just told them we don't have anything here? This is a natural client for any client to have under the circumstances, and equally available inference from this evidence is that President Trump believed the boxes that were moved contained sensitive items he had designated as personal records under the PRA and were not responsive to the Trump office subpoena. And as Judge Howell acknowledged, neither President Trump nor Person 18 responded to the Trump office subpoena by claiming blank. Reasoning that President Trump's question taken alone may be insufficient to establish the applicability of crime-fraud exception where the attorney-client relationship has worked exactly as intended and deserves the utmost protection. Reasoning that the crime-fraud exception does not, by its terms, apply to the situation where the client consults an attorney about a possible course of action and later forms the intent to undertake that action. Finally, the special counsel's office did not establish any nexus to allege criminality concerning Person 18, June 24th, 2022, call with President Trump. Another Trump phone call that's going to get him in trouble. Damn. That guy just needs to stay off the phone. That's my legal advice to President Trump. Just stay off the phone, bro. Just stay off the phone. But the office's evidentiary proffer focused on the issuance of the Trump Organization subpoena and Walt Nauta's efforts to return to Mar-a-Lago shortly thereafter. The evidence was equally supportive of the interference that President Trump and others took the Trump Organization subpoena seriously, and the office was not entitled to access President Trump's privileged communications regarding that issue. The communications did not further any crimes. So this is the next one that they alleged, and they're saying that it was not done in the furtherance of any other crimes. At the second step of the crime fraud analysis, Judge Howell erred by concluding that President Trump's communication with Person 18 and blank and related work product furthered the alleged offenses relied upon by special counsel's office. The evidence of steps taken by Person 18 and Person 12 and the corresponding advice they provided to President Trump demonstrated that the advice was intended to prevent unlawful conduct. And an opinion there by the late, great Ruth Bader Ginsburg. Or a party? I don't know. Yeah. Even if the office had established that President Trump failed to heed his lawyer's counsel and they did not do so, such a failure does not alter this crucial facet of the case. See also United States versus Jacobs. A wrongdoer's failure to heed the advice of his or her lawyer does not remove the privilege. So basically what they're saying there is just because he disregarded the advice doesn't mean he's entitled to give up the privilege. You have the ability to say, no, I don't want the advice, and that's perfectly reasonable. To not want the advice of your attorney. Maybe it's bad advice. Who knows? Like I said, he did have Michael Cohen as an attorney for a while, so he certainly probably got some bad advice somewhere down the road. So it's not unreasonable to say, and plus the man has so many attorneys. Like, not all of the ideas provided are going to be gold. So I can see probably why he wouldn't have taken advice in a certain circumstance, but that's should be up to him and his privilege. It shouldn't be afforded to the state to be able to make that determination as to what is good advice. So blah blah blah. There's a bunch of citations. The crime fraud exception to the attorney-client privilege cannot be successfully invoked merely upon showing that the client communicated with counsel while the client was engaged in criminal activity. The fact that a privileged communication may help prove that a crime occurred, which did not happen here. does not mean that the communication was used in perpetrating the crime. And I think it's unreasonable to think that just because you get advice from a lawyer doesn't mean that you're trying to make the perfect crime. You're just getting advice from the attorney because you're maybe not trying to commit a crime. I mean, there are several instances where you're getting advice from an attorney and could be, but it didn't appear to, and there's not really any relevant information to say that it's because he was trying to commit a major crime here. So, yeah. Judge Howell's ruling eviscerated President Trump's privilege under circumstances where even its stern critics acknowledge that justifications for the shield are strongest, where a client seeks counsel's advice to determine the legality of the conduct before the client takes any action. And I would think that would be reasonable to ask if something's legal before you pursue it. It's generally a good idea to ask if you should do. If you're not sure, ask if you should do it before you do it. But number 3, the compelled waiver was overly broad. So here we go, getting back to just more overly broad in every single way information. Like there was no specificity to anything that was put out. It was just all this big trap, and that again is not supposed to be the way that things go down. So district courts should define the scope of the crime fraud exception narrowly. Hey, what's up, Amit? Enough so that information outside the exception will not be elicited before the grand jury. Judge Howell failed in this regard too. For example, the court failed to explain how person 18's invoices, execution of an engagement letter, and correspondence with an associate in advance of the May 23rd, 2022 meeting could have possibly furthered the allegedly illegal conduct. The existence of a crime or fraud does not create a blanket evisceration of privilege. It only extinguishes the privilege for the communications and documents connected to the crime or fraud. So it's not an all or nothing thing. So it's not, oh, you had, these one communications, so everything that you put out is now gone. It's only related to should have been related to one specific set, not this big overarching grab that they seem to have done. And that seems to be consistent with every single thing they undertook or did. It's just this broad spectrum. Let's see what's out there. Really don't care about his rights or the law. We're just gonna do whatever the hell we want and just deal with it, President Trump. Like nobody cares. Operation Bum Rush. Yeah. Yeah, that's still just insane to me that they're just the whole civilian dress thing, like just incredibly dangerous. And thankfully, again, President Trump didn't react in a way that would have inflamed tensions or made things worse. Because he probably could have. And it probably would have been justified, but that would have gave and that's what it seems more and more that we get into this and more we read this, that this was all just a media ploy. It was nothing more than them trying to get a story or stories out into the media to make Trump look like shit even more than they already had. And that seems to be the intention behind everything that they've done so far. Just make Trump look bad. That's the whole goal of the exercise, is let's make Trump look bad and worse. And that's unfortunate because That shouldn't be the role of the government. The role of the government should be, protection and combined defense, that kind of shit. Not frame a president and make him try and kill a sworn law enforcement officer so we can put out a news story on CNN. Like, I don't think that's written in our Constitution anywhere. I haven't read it. If anybody has a citation, you're welcome to pass it along to me. I'd be happy to read that chapter. But so anyways, for example, the court failed to explain how. Oh shit! I keep doing that. I keep going back. Judge Howe also required disclosure of 6 emails in a draft to the Trump Organization subpoena that Bratt sent to redacted. The court reasoned that these documents inform Person 18's preparations for the June 24th, 2022 call with President Trump. Who gives a damn if they did? However, there's no basis to conclude that Person 18's preparations for the call furthered any of the alleged misconduct. And a good thing to remember here is the alleged misconduct that they're speaking of is also bullshit. So there's bullshit charges to go with bullshit everything, just to include more bullshit. So this whole thing is truly just complete bullshit. So it doesn't make any sense at all. But we would continue reading. The proper reach of the crime fraud exception, when applicable, does not extend to all communication made in the course of attorney-client relationship, but rather is limited to those communications and documents in further of the contemplated or ongoing criminal fraudulent conduct. Therefore, the special counsel's office was not entitled to those documents. So, yet again, here's another overlapping where they weren't entitled to anything. These are the so-called protectors of democracy. Yeah. There's a concern whether democracy even exists anymore. I mean, you can say democracy, constitutional republic, same damn thing, whatever. I don't think any of our systems of government work anymore. So, it's unfortunate. So, Judge Howell also ordered disclosures relating to the certification that Person 12 signed regarding the Trump office subpoena. The certification stated that representations it contained were based upon the information that had been provided to me. No one for President Trump's side hid that. I don't think that's a basis in law if you hide the information, but I get what they're trying to say. Again, I think they're just trying to placate somebody that there's no making these people happy. Like, no matter what you do, they're gonna fuck you over at every turn. So stop trying to make them happy and just tell them to go fuck themselves, maybe. Is my response, but it's just me. However, the court reasoned inaccurately that the certification was incorrect and unreliable, at worst, intentional misrepresentation, and drew improper inferences about what fulsome certification would entail. Certifications produced by the special counsel's office in discovery illustrate that the court was wrong. Based on this erroneous reasoning, the court improperly ordered disclosure of privileged information relating to the certification. So Trump got screwed again. The court, number 4, the court misapplied their opinion work product doctrine. Although the special counsel's office concluded that it had no right to Person 18's opinion work product, Judge Howell defied that category in an unlawfully narrow and extremely prejudicial fashion with respect to May 2022 recording and the June 2022 recording. The office quoted from the recordings extensively in the superseding indictment. The indictment where they got the information that they wanted, and then they went back and fixed it so that it was amenable to the actions that they took. So they took the actions and then went back and justified and fixed the actions so that it fit what they were looking for. So it's always beautiful. The recordings reflected Person 18's observations of the events he deemed to be significant during his representation of President Trump, visits to Mar-a-Lago, and assistance in responding to the Trump office subpoena. Opinion work product may be reflected in something as subtle as the act of selecting or ordering documents because they may reflect an attorney's opinion to the significance of those documents in preparation for the case. Attorney notes reveal an attorney's legal conclusions because when taking notes, an attorney may often focus on those facts that she deems legally significant. The selection of the compilation of documents by special counsel, in this case, in preparation for pretrial discovery, falls within highly protected category of opinion work product. Therefore, in addition to disclosing communications that were subject to an attorney-client privilege, the May 2022 recording and the June 2022 recording disclosed Person 18's opinion work product in connection with representing President Trump. The special counsel's office expressly was not seeking such materials because of the legal problems with their theory, and the office should not have been granted access to the recordings. The evidence relating to the May 2022 recording and the June 2022 recording shall be or should be suppressed. Finally, because of the high prejudicial nature in which the special counsel's office used the privileged evidence, including through extensive quotations in the superseding indictment, the court should dismiss the charges. Describing the multi-day hearing relating to the extent of privilege violation and assessment of resulting prejudice. So we'll read the conclusion and then we'll go through. So for the foregoing reasons, President Trump respectively submits that the court should suppress the evidence seized during the unconstitutional raid of Mar-a-Lago and obtained from the unlawful violation of President Trump's attorney-client privilege and dismiss the superseding indictment following a hearing on prejudice resulting from the privilege violation. So basically what the Trump team is saying, and I think rightfully so, is that if the government did their job properly or correctly, there would be no indictment. There was no ability for them to be able to do so. They wouldn't have got the documents, they wouldn't have got the indictment, and they wouldn't have been able to put forward anything that would have been reasonably understood to be able to do any of that. So there's truly an instance where they should have been able to suppress a lot of this information. If they weren't able to suppress a lot of this information, then they should have been able to make changes to it. And the fact that they couldn't have done any of those things or mitigated it in any way, and the government showed no intention to mitigate anything in any way, that the whole damn thing should be thrown out. And it's really hard to be able to argue with that point of view because I tend to agree with it. I tend to agree with the fact that I don't think the government gets there unless they have what they need through illegal means or through means that aren't conducive to the way that it should have been done. So the government should drop this sham charges against the president as well, and they should be able to go back and start over. So we owe this judge big time. Yeah. The Trump admin hasn't went after the judge at all in this case, which is interesting. At all, they seem to be far more interested in the way the attorneys and the special counsel and obviously Merrick Garland handled things. So, but yeah, I mean, it what it comes down to is it's another screw job, and it's more bullshit that Trump has to deal with unnecessarily, and shouldn't have to. So, should not have to. And I guess I'm at a point where how do we rectify this? What do we do from this point? Because it's clear that the government's not gonna make any changes. It's not gonna do anything. It's just gonna continue to trample on our rights. It's gonna continue to do terrible things and continue to do what they want instead of what the law is prescribed to do. So I don't know how we change it or how we take a step back or any of those things. But this is truly scary because again, if they can do it to President Trump, they can do it to any one of us, and it would be far more easier to do it to you or I than it would be to the president of the United States or former president of the United States. So it is. It's truly concerning. It's deeply worrying, and I hope she can't just throw it out with them being able to refile. I think she has to force everything into light so they can't appeal either. Well, that makes sense. I mean, I can see that too. And there's always some kind of always some kind of dance that they have to do to try and get around this, that, or the other thing. You just wish sometimes that the law would just work instead of having to work in a ridiculous fashion, that it would just plainly work. And I understand that's not how it is. It's slow and painstaking and all that stuff, but damn, it'd be nice if one time it just worked like it was supposed to, and we could get it over with and move on from it. And it's unfortunate. I'm worried about what this means going forward and what we do from here, because it doesn't seem like it's going to end anytime soon, especially with November coming up, and there's going to be more bullshit. There's going to be more that they're on Trump about, and I don't know, we'll see. So we'll see. But so that is the President Trump stuff. The rest of it is all kind of supporting documents for that, but they went through it very well. And we've all seen the stuff associated with it. There was an interesting document that was put out last week that was his attorney Nauta. They basically put out his entire transcript. It is 67 pages. No, I'm not reading it. I'll read it if somebody wants to read the other one with me. We could play lawyer and lawyer. But yeah, it's 67 pages. So Nauta or Naka, the other attorney, it is the transcript. So that was released. I'm trying to see what else was released, because there was a bunch of stuff that was released last week in advance of their filing. So affidavit application. So yeah, I guess I'll I'll show this. So this is just notice of filing. So it's just a notice that they would be filing or they have filed based on the search warrant. And then, like I said, here is, let me see what this guy's name actually is. Walt Nauta and Mr. Bratt. So it's Mr. Bratt and Mr. Nauta. So it's 67 pages of just the and of course heavily redacted. But there's 67 pages of the interview. So maybe something I'll do at some point. Not tonight, but maybe something I'll do at some point. Yeah, it is tedious. It is very tedious, and yeah, I'm not a fantastic reader. Like, I get through it, but some people are much better readers than me. Just out loud. So, but yeah, so there's 67 pages of this information. Maybe I'll set it up and see if Brian will join me or something, and one of us will play cop and one of us will play attorney. So, hey, no worries. I enjoy it. So, and then the last document is, so there is, this one's the interesting one that, what's up, Chase? It's gonna get worse, buddy. It's gonna get worse. And maybe I'll do that. Maybe I'll do, because it's already been 90 minutes. So by the time I start something, it's gonna be like 2 hours before I'm done. So this is the last exhibit that was released last week, and this was this is the cover sheet. Obviously, there is a motion to seal on some various things, and then there's all kinds of there's sealing orders. Obviously, we can see the application for warrant. So I think this one's an interesting one, and I mean, hell, maybe I'll do this one tomorrow, and we'll go through these 47 pages. But this is the affidavit in support of an application. So this is the actual application for the warrant, the application for the file under seal, and this is all stuff that was released last week. So maybe we'll do that. Maybe we'll cut tonight. I forget when he goes too. I used to watch him a lot more. I just don't have the opportunity as much to watch as much other content, but just send me a message and tell me when. So, but yeah, that's probably what I'll do. So we'll do 8:30 tomorrow, and we'll go over the actual filing of the warrant and all that, because there's some interesting stuff in here as well, as you can see. So, okay. So we'll head through that, and then give me some time to read through the testimony, and I'll do that tonight. And if there's anything incredibly interesting, I'll highlight that tomorrow too. So, but yeah, I wanted to finish up that. For those who don't know or didn't hear, also before I wrap it up for tonight and then pick it up again, President Biden, former Vice President Biden, has been removed from the ballot in Ohio. There's going to be legal challenges and things of that nature, but he has been removed according to the administration in the state of Ohio. So that's nothing but good news, because that means Trump automatically wins a swing state. So any help we can get with all the cheating and bullshit that's going to go on is going to be very much appreciated. So I'm very excited that that he's not going to be on that ballot, and hopefully it holds, but that's the indication, at least right now. So hopefully he gets kept off the ballot, and I know in the past, generally, I've said, let's not play their game, and I'd rather have both of them on the ballot and play it out. But I'm kind of at fuck that, because they're going to cheat as hard as they can. So it might be one of those we have to play the same game, same game, same rules, or we're doomed to repeat failure. So hopefully. But yeah, so that's the state of Ohio has said that Joe Biden will not be on the presidential ballot. So it's and a little bit behind what it is. He'll be nominated because of the way the Democrats are holding their nominating convention. He'll be nominated after the cutoff, which there's a process for, a filing process or a legal filing process. But the Biden administration has chosen not to undertake that filing process. So the state of Ohio has said, basically, screw you, and then you won't be on the ballot. So, and instead of doing something there, they seem to be kind of taking it in stride and just saying, kind of challenging the state of Ohio to exclude them. So it seems to be a game of chicken, and I'm ready to play. I think it'll be fun to watch. So that's what's going on currently in Ohio. Terrible state, but maybe they can be good for something and come through with something. But we got to take the little wins when we can. It's not every day. Also, I said at the beginning of the program, but for those who like the launches and things of that nature, Boeing has canceled their flight indefinitely of Boeing Starliner, and the astronauts will be cycled and no longer be flying the mission when it eventually does take off. So the current astronauts that were going to be on this test flight, it is rolled back in. It is under indefinite suspension of the flight, and these astronauts will not be flying on it. So unfortunate, but depending on your stance on Boeing, because there could be some indication that it fails. So they dodged a bullet, but there's also a chance that they could have been able to take a ride to space, and that's a pretty cool honor. So bittersweet, but yeah, easy way to play victim. Yeah, of course they're gonna spin it and say, oh, blah blah blah, and they'll use it later to keep Trump out of something. So it'll be a justification and a spin zone type tactic. So, but that just came down today as well. So that's gonna be it for me this evening. Boeing doesn't need to. Yeah, they don't need to kill astronauts. That would be bad. But so that's gonna be it for me this evening. Same time tomorrow, 8:30 Eastern time, and we will go through this document, which is the original warrant, because there's some really interesting things in there as well. So we'll get to that one. Thank you for stopping by. Please hit like on the way out, and until next time, hope everyone has a good night. Take care.